I'd like now to give the floor to Professor Mazet. As I said before, Professor Mazet wrote a thesis on legal vocabulary, so he's following closely the emergence of legal vocabularies as expert, and he knows the qualitative jump we can make by using artificial intelligence to translate the law. But Professor Mazet also says that legal information as a raw data will transform into knowledge when it is used by lawyers or experts. So we could say the intellectual practice of legal translators as well. So I'd like to have your opinion on the automatic or machine translation of the law. Legal multilingualism presents different aspects and different difficulties that can be related to the translation problems and to the issues related to compared law. Indeed, compared law is an information tool that reflects upon the diversity of laws and, of course, the diversity of languages. In one uniform legal language, you will find issues of legal systems diversity. Now, in a linear way, we can understand that so far we've been talking about conceptual descriptors of terms and terminology, but one needs to know that the semantic aspect of translation is not the only one. We also have the syntax aspect. Indeed, legal vocabulary is integrated in the language of one country where it was born. This adds one further layer of difficulty. Indeed, we have there to look at the characteristics of the natural language, because legal jargon, legal language presents different aspects that are added to the natural language, and therefore syntax will disturb the legal language. Let me give you an example. If you want certain rules to apply, or if you look at the different application derivatives, it's one thing. But if you find that in one sentence a rule is not applicable in one situation, we're talking about non-application and not application. So these issues of syntax are of course important and should not be ignored. So far we will limit ourselves to examining the issues and discuss the issue of legal multilingualism on 2 points. There is a problem of legal multilingualism when one single legal order knows different languages. It is the case with EU law. We have the obligation here to obtain texts whose meaning, spirit and effects are perfectly equivalent in each one of the official languages. Indeed, the objective is to make sure identical rules emerge simultaneously in different languages. This is a first hypothesis. EU law is expressed in different languages. Another phase of legal translation is that of modalities to access other laws. The objective of Legivoc is to compose an instrument giving access to laws in the European Union sphere. But what happens? Sending queries in foreign legal dossiers makes it difficult for a legal expert, because there will be a confrontation of terms that is very much part and parcel of compared law. This is why we need to create tools and instruments that will be capable of managing this comparison. In other words, we must be able to navigate towards relevant information without prejudice to the integrity of the relevant national legal laws. This is on the verge of interpretation and goes well beyond translation. Indeed, there is a tight connection between legal concepts and the language that expresses them. This strict connection between language and the law will make it difficult to translate the law, and will of course mean that sometimes the translator will have to reflect upon the creation. When confronted with legal terms, we can have a morpho-semantical equivalence first. This is the equivalence of a pure literal translation, where, in this case, we have a complete formal and semantic equivalence. I will take the Italian case of bilan, bilancio, the acquisition of the legal personality, same thing. But we need to be very careful, because in a large number of cases, the morphological equivalence is not related to the semantic equivalence. It's the case of administrateur and administratore. In Italian law, the term administrator is used for all leaders, whatever their position. In France, we use the term only in limited companies with a board of directors. So we see how perilous this can be when it comes to accessing information. And when we want to take a semantic equivalent with a term that is morphologically similar. The other difficulty is related to the conceptual equivalence expressed with specific descriptors in each language. For instance, the concept of statute is atto constitutivo in Italian, statut. But the translation of atto constitutivo is always possible, but it does not correspond to the same concept in French law. These are not the statutes of a company. So we see the problem with automated translation. This will lead to noise, if I may say, to non-relevant translations in French law, and it will be incorrect or incomplete in the Italian system. Another possibility is a very important point, an important case where we have the legal jargon which is specific to one given legal system and has no equivalent in another legal system. This is the case in, well, collective or class action. We do have class action in some countries, Italy, I think, maybe others, and we could translate, well, collective action by group action, but class action, as we know it in the US law, does not correspond to action de groupe in French law. Action de groupe is only for trade or consumption law, and in US law it applies to all sorts of other legal domains. So we see how difficult it can be. What I'm saying is that the legal equivalence does not take into consideration the crossing of legal systems. This is why it is so important to look for a level of intrinsic relationship existing between two legal orders, beyond the simple legal translation in the classical meaning of the term. This is what we call the functional equivalence. We will look for an operational relationship, and we will try to go beyond the technical level of application of a legal norm to reach the objective that this legal rule or norm pretends to achieve. So this is when we look for the equivalence of the functions of a legal standard in order to obtain an equivalence that will translate similarity, analogy, or even synonymity. The idea is to even attempt at identifying this equivalence in functions. We find it methodologically in the analysis of the functions contained in the texts themselves. Indeed, a number of definitions are real rules to interpret the sentence that allow to interpret the modalities of interpretation and application of a law or rule. So the equivalence obtained between two legal systems will then operate in the following way. Within each legal order, internally, nationally, topics will be structured. Whether we're talking about an institution or a body, we will do so following the method suggested in the different thesaurs we will present it, with connections and relating the different descriptors in different models through information and others, and then we will proceed to interconnecting the structures that were created. This interconnection of structures will operate based on the functional equivalence. Now, this may appear at a general level, but also at a very technical and specific level. The application of this rule has a broader scope than the simple relevance of having access to a foreign legal law and rule. So through the internal navigation of a system, we will show similarities, affinities, differences, divergences. In other words, we will be able to measure their degree of integration. In other words, we will somehow deliver the keys to harmonizing the different legal systems, and this is absolutely fundamental. We see here a real renewal, renovation of the comparative method, because so far practitioners are no longer satisfied with the knowledge of the simple fundamental principles of foreign law. These were the principles of Savigny in the past century. Today, legal experts, practitioners, want to apprehend a legal order in its specificity, technicity, and autonomy. The innovation today is very much the fact of new technologies and IT. Thanks to this new tool, legal experts can look at facts in a foreign legal order. They know how a foreign legal order will react in a case similar to the one at hand in their national legal order. And therefore, this can be easily translated in its total objectivity and concrete aspects. From that point of view on, based on the specific rule that will apply in the case at hand, we can base the operation on the legal concepts, but also, this is fundamental methodologically speaking, based on the implementation of the legal concept, but also the implementation of the semantic fields of the concept. These semantic fields, through the legal concepts, will give order and create order in the conceptual environment. This is particularly interesting because in application of several semantic relationships, such as assumption or inclusion, we can proceed and based on a certain fact, on a certain given concrete fact and case, and we can deduct the legal architecture that commands this fact up to the most abstract level. So indeed, the interpretation of the fact is completely new, and there's a radically new dimension that will be attributed to the facts. If I am, let's take the assumption that I'm a foreign legal expert and I don't know French, I don't know the legal system that prevails in France. And if I take, for instance, the example of pollution by hydrocarbons. Hydrocarbons is a concept that can be translated. But if I ask for the interpretation through the induction, I will find waste as well. Because if you add hydrocarbons to salted water and certain minerals, I mean, it creates waste. It is considered as waste in the framework of the directive. I can't remember what the number of this directive is, but this directive says that we are in the presence of waste, and that those responsible for the pollution and for this waste in seawater can be the person that sold the hydrocarbons, or even, why not, the owner of the ship. So we started from a factual concept, hydrocarbons, and through the structure, through our navigation in the structure, through the semantic concepts, we've been able to reach the concept of the first owner. We have indeed moved towards the law, the legal concept, simply starting with the fact. So we changed the scale of comparison without any prejudice to the legal system concerned, that is the one where we find the directive, or the national systems that adopted the directive and translated it in their internal law system. So this is how the issue can be described so far. I moved fairly quickly there, but we may be able to see later on what methodologies can be proposed when it comes to comparing laws when queries are sent through the national systems. Thank you. Thank you very much, Mr. Mazet. We could come back to the Légivore.